you know, but it doesn't have to be. And you take solace in the fact knowing that preparing a will and having your other estate planning documents in order makes it a lot easier on your family once something happens to you or if you passed away. Because not only would your family members or spouse, whomever, be dealing with the grief of losing you, they would also be trying to figure out, what did you want? What property did you want to go to whom? You know, all these different things. Who do you want to represent your estate? And that's when it starts to become an issue with estates and family members and bickering. And I've seen some very, very nice mannered, well-mannered families pre-death of the father or the mother getting at each other's throats after one of them passes away. It's an unfortunate situation that could have easily been remedied if everyone had, or if the decedent had prepared her will and powers of attorney. So what's the primary reason people don't have a will or other estate planning documents? Procrastination. And we just touched on a few reasons why it's not a good idea to procrastinate. I believe it's too expensive. So as a Legal Shield member, you are entitled to what we call a basic last will and testament. And for 95% of our clients, that gets you farther along than you need to be. Everything you need is included in that will. You say who you want your executor is going to be, the guardian of any minor children or disabled family members. Trustee, if you have a minor's trust or you have a revocable trust or other type of trust, and who you want all of your property to go to. Another one, people don't understand why they don't need a will or why they need a will. We just covered most of those reasons, but we'll also hit a few other topics as we go forward. So what does a will do? In addition to the different benefits we talked about a minute or two ago, it tells your executor where you want all of your assets to go. Who gets what? How much of that asset do they get? If is the person, do they have to fulfill some sort of condition to get that property? Does your nephew Johnny need to go to college to be able to access the money that you left for him in trust because he was 12 at the time of your passing? You can have those conditions written into your will for that money to be held after you pass in trust for that minor beneficiary. It's all included in your basic will. Appoint someone as your executor. The executor is an important decision because it's the person that is going to be in charge of opening your estate, marshaling all of your assets, which just means gathering up all of your assets, figuring out how much money is in the estate. Is there enough money to pay debts if there are debts? Is there enough money to pay the administrative expenses, which can include things such as opening the estate, legal advertising of the estate, the inheritance discounted prepayment, which is due within 90 days of your passing, things like that. If there were any final medical bills as a result of a stay in a hospital or funeral expenses, our fee for handling, representing the estate. If there is an accountant that's going to prepare your final income tax return. Those are all things that the executor is going to have to figure out. So you want it to be someone that is, financially responsible and someone you can count on. It doesn't have to be a family member. It doesn't have to be, someone, an attorney or an accountant. It can be anyone that you trust to represent your interests after you pass. Again, we touched on this earlier. You're going to appoint a person to take care of your minor children. And that person does not need to be the same as your executor, or if you have a minor's trust for the benefit of someone that's under 18, or whatever age you want to have them inherit the property. The minor guardian can be different and separate from the executor and trustee if you have one. And finally, let's say you have a family, you were married, you have a kid or two, doesn't work out, subsequently get remarried, and your spouse has children from a prior relationship. Subsequently, you and your second spouse, you get really close with your stepkids, and you decide you don't have a will. Everyone will figure it out after you pass. It's on them. And guess what? Those stepkids don't get anything under Pennsylvania intestacy laws. However, with a will, you can now leave property to those non-family members, unrelated people, and stepchildren, friends, same-sex couples. All of these are includable in a will for you to leave. Have a provision that includes distribution to them upon your passing. Moving on to further into the intestacy situation, which is what happens when you pass the will. The state or the federal government are not going to be your friend or ally, or your family member's friends or ally whenever you pass away. If you don't have a will and you didn't name a beneficiary, there's certain succession, I think there are 4 or 5 in total, before it ends up getting down to the state. Because if you don't have a beneficiary and there's no one else around, no one can figure out where your property was to go, or more importantly, no one steps up to represent your interest in making sure your property passes to your heirs, then it's eventually going to go to the state. Nobody wants their money to go to the estate, to the state. Recently, with COVID and everything else that's going on, trust in government is at an all-time low. So it's important to be proactive and take matters into your own hands and put your wishes down on a piece of paper, known as a will. Another consideration is the quote-unquote American family has changed quite a bit over the last 2 or 3 decades, while the intestacy laws have remained pretty stagnant. Again, those intestacy laws do not account for same-sex marriages, blended families, which would be second marriages, stepchildren. They don't count for friends or anyone other than in your lineal line of descendants. Would be you, parents, grandparents, down to your kids. Some of these issues that you see on the screen now are, somewhat up in the air, but can all be addressed directly in a will or a trust or other estate planning documents. Grandparents as primary caregivers, in vitro, unmarried couples. And by the way, common law has not been recognized in Pennsylvania for it's probably coming up in 20 years, in the next year or 2. And same-sex marriages also not recognized in the intestacy statute. It's only lineal descendants. So what assets does a will not cover? The first is jointly titled assets. So if you own property with you own a bank account with your mom, that is not subject to the will. These items that we're going to talk about pass outside of probate. And what matters is what's on file with the financial institution or the company that has the asset, not what's in your will. Real estate deeds that you own with a family member. If you own it with right of survivorship, or you own it with your spouse, it automatically transfers to those surviving owners upon your passing. Other things, think about life insurance policies, term life insurance policy. The beneficiary on file is who controls who they're going to pay that money to. So if you don't have anyone on file, typically it'll default to your estate. It's just not a good idea, because then if you don't have a will, that money is going to go paid out in accordance with the intestacy laws that we discussed a few slides ago. If you have someone in your will, and you say that they are to get the death benefit of your life insurance policy, and you don't have anyone on file with the life insurance company, that person's not going to get the money. It doesn't matter. It's going to go to whoever is on file, or if no one's on file, it'll go to your estate. And that's something that people need to check in, after different life events, such as divorce, new children, adoption, things like that. Those are all times that you need to sit down and consider what has changed. How do I best update my forms, my estate planning documents to make sure that these new changes in my life are going to be taken care of and are addressed. That's a good time to give us a call. Again, assets controlled by beneficiary form, so life insurance policies, but also things like your IRA or 401k. Those have beneficiary designations that work the same way as the term life insurance policy that we were just discussing. It matters who is on file. It does not matter what your will says. These assets, otherwise known as non-probate assets, pass outside of your estate in your will. And finally, assets in trust typically pass outside of probate as well, because upon your passing, as long as a year has passed between that transfer from you to your revocable trust or irrevocable trust, it will not be included in your estate. And that's more something that we could discuss on a one-on-one basis, or if you have questions after the presentation, try to address those questions at the time. So let's go through those 5 situations I mentioned earlier where it's not a good situation. You pass without a will. So the importance why we're bringing this up is knowing what happens if you didn't have a will, and hopefully create a sense of urgency in you to make contact with us and get your estate planning documents out of the way. And again, the basic will, durable power of attorney, healthcare power of attorney, living will included in your legal shield membership. So what happens with blended families? We touched on this earlier, but this would include situations where you had children from a prior marriage or relationship. So the surviving spouse splits estate with your children of your prior marriage relationship, where the guardian for assets left to minors. What those children from your new relationship, if you want to leave anything from them, it's not going to happen. And if you still have everything set up with your prior spouse named on your beneficiary policies or beneficiary will, it's not going to go to them, but it's going to create some issues. You're unmarried, have a long-time girlfriend or boyfriend. Survivor gets nothing if you pass and you don't have beneficiary designations with their name on it or have a will. But if you have a home where, let's say, one of you purchase the home in your name and subsequently start dating someone and things go well, they move in, they start putting money down on the mortgage. If you pass or if they pass and the situation was reversed, whoever moved in was the second to move in, it was making mortgage payments, but didn't have their name on the deed, is going to be a bit of a pickle. They're not going to have any claim to that property. If you have a will, you could name them as that they get their share of whatever they contributed or any variation of that. So what happens with stepchildren? Again, not treated the same as your children. They get nothing in intestacy without a will. You don't leave a provision for them. No one's going to be able to read your mind. If you never said anything that they were going to get property, and even if you did directly tell them that they were going to get a portion of your estate, it's not in the will. That's it. If someone wants to challenge what they're saying, they have no claim against your estate. What about single parents? Who's going to handle the money, your estate, for the benefit of your children if you don't have a will? If you haven't memorialized who you want to be guardian of your children in your will, no one's going to know who it is. What's going to happen is the court's going to step in and appoint someone. No one wants that. If you're divorced, would you want your money going to your X to hold and manage for the benefit of your children. Who cares for your minor children if that parent disappears or isn't a good parent, is mismanaging the trust funds? If you don't have that guardian written down in your will, if you want to be in control of your money for the benefit of your children, you're going to leave it up to the courts. And they're either going to appoint the ex or the other parent, or they'll find some other even less desirable means of taking care of your children. What happens if you're single and don't have any kids? Why do I need a will? I don't have any property I want to leave behind. If you're just starting out and working, it's going to take a little bit of time to build up a portfolio or buy a house, things like that. But if you do pass, who's going to handle all of the assets that you do have? Who's going to get the assets that you do have? It's going to revert back to the intestacy statute that we discussed earlier at the beginning of the presentation. What if your parents are elderly and medical assistance issues and they're on Medicaid? If they inherit property from their single kid who's not have any children of their own, they're going to get disqualified for any government benefits they have. Whereas if you have a will and you set up a special needs trust for the benefit of the person that is on government assistance or Medicaid, is a way to a workaround. So how can we get started? You have the Legal Shield Will app. We have paper questionnaires that we can mail or email to you. You can also go to our website, which is fiffiklaw.com. Legal Shield Will app is available on iTunes and Google Play. Get started anytime, anywhere.
Hey, Ed, if I can quick jump in, if you don't mind. As everyone knows, Legal Shield has the new app that they've developed that members can now submit their requests for services via the mobile app. They've now also initiated the web version that you can go on through the Legal Shield portal and open up your own intake that way. When you're discussing with your members to have them do this, we still need the will questionnaire to be completed. So when they open up an intake via the will via the mobile app, it's I want to get a will done and I need to get the durable general power of attorney and the healthcare power of attorney. That's great. However, we still need to go through all of the questions in the will questionnaire so we can accurately complete the will, the wills for the members. I think there's some false expectations with the members when they think that they're opening up the mobile app or the web version of the app, that things will get done quicker. We still need the will questionnaire to be completed. So if you're talking to a member, please let them know. It's great that they're utilizing these new ways to get in touch with us, but we're still going to need them to complete the will questionnaire. Sorry, Ed, go ahead.
Oh, no, thank you. That reminded me to say, this isn't particularly long process getting your estate planning documents done, but it's not going to be overnight either. So everyone who's working will be working very hard to get your documents to you as soon as possible. Just like everyone to be aware of that. Just going with what Naomi just said. Thank you, Naomi.
You're welcome, Ed.
I think we just hit that. Fiffiklaw.com is our website. Important to think about, make it easier on yourself before you get that questionnaire. Think about, well, obviously, your name and your address and date of birth, things like that. You need your spouse's information, names, addresses, birth dates of children, if they're minors, if I need the birthdays so we can decide what kind of planning you'll need or best suits your family's needs. There's also a few different options to pick from how you want your property to go. Typically with the basic wills, one of those three options is about what you're going to have to, is about it for the basic will before we'll get kicked over to Fiffik Law Group to handle your estate planning documents. But those three sets of circumstances cover 97% of the Legal Shield members that have come through, at least since I've been here. So, and if you have questions about any of the documents, one of the Legal Shield staff will be more than happy to answer those questions. But the more information, go through the will questionnaire, go through things that get you thinking about everything that you'll have questions about. You want to talk to with the attorney, what information you'll need, what information if you don't have, you can start looking for. I also need to know if you have a pre or post nuptial agreement. If there are any disabled, whether it's mentally or physically disabled beneficiaries, children, parents, relatives that you're going to be leaving property to in your will, and also whether or not any of either the spouse or children or beneficiaries are U.S. citizens or green card holders. Finally, touched on this a little bit earlier. These three people do not need to be the same person. They don't have to have any sort of schooling or education requirement. The only thing I suggest thinking about is making sure you trust this person. They're accountable, they're dependable, and they're able to handle finances in a mature manner, not a spendthrift. So you want to think about your executor. That's the person that's going to open your estate and file your final income tax return, inheritance tax return, and make sure all your property goes to the people that you name in your will. A guardian for the minor beneficiaries and children, and then a trustee, which will only come into play if you have what's called a testamentary trust, which just says in your will that you're going to have a trust set up for this particular class of beneficiaries, whether it's your minor kids, your beneficiary, or someone with special needs, or more of an incentive type thing. If you want to your child that they can access only if they go to college, so they can spend it on room, board, and books, good times, things like that. It's also something that can be written in. Next, we have also assets and debts. Think about loss and financial information. If you feel that any of it is too personal, or why are they asking this, you can just pull a little note, say we'll discuss on the phone. Don't feel overly burdened or overwhelmed to fill out every little piece of information. The primary things we'll need are what we went over in the last 3 or 4 slides. And then also, if you give us an idea of what your assets and debts look like, if any. You can help us discuss. Yep.
Sorry, if I may interrupt one more time. Just so you are aware that we will have one of our paralegals reach out to the members to go over any missing information from their will queue. So we'll have someone from our office double check with your member to make sure they've listed all of their assets and debts, because this is very important for the attorney to have all this information when speaking with the member. So that is customary for our office to reach out to the member with one of our paralegals. Sorry, go ahead, Ed.
Thanks again. That's another thing. If there are missing items or you have questions, that's one of the reasons why someone will reach out to go over your questionnaire with you again. We want to make sure that we have your documents exactly the way you want them, and trying to cut down on time as much as we can, trying to be efficient and as effective as possible. So why are we asking for these assets and debts? It will help us decide the best plan or way forward from a federal taxation standpoint and an inheritance tax standpoint. So inheritance tax is payable to Pennsylvania. Income tax obviously is federal government. If there's any out-of-state property, it's another thing, consideration that we'll have to take into account. And then specific requests or things, if you have a rare stamp collection that you want to go to your niece Ray, you put that in your will as a specific request. Then we can talk about what happens if it's not in property. or in your estate at the time of your passing. That's something one of the attorneys can discuss with you after you submit your completed questionnaire. Or if you have a muscle card you want to leave for your grandson, you can put that there as well. Those kinds of things where you have someone in mind for a specific piece of property will include in your will. And typically we attach that to the back and make it easy for you. As a personal property memorandum. And not to confuse things, but we can also discuss that when we call to go over your will questionnaire. So after you submit your questionnaire, if it's all completed and there's nothing missing or nothing that the paralegals don't want to reach out to you and review, remember to call Legal Shield or Fiffik Law Group with any questions or concerns you have. Remember, every situation is different. There's no one size fits all option. And occasionally we will need additional information that's not asked for in the will questionnaire. But again, if it's anything that you are uncomfortable with writing down, you can have a conversation about it over the phone and tell you why we need it, why it's important we need it. We'll go from there. So how does this process work? So you request the will questionnaire on the app or website. An intake gets opened in Legal Shield. Actually, no, I mean, can I let you talk about this part?
Sure, I'll be more than
Is there
happy to
anything I'm
do that.
missing?
Yeah, sure.
Thank you.
So what happens when your members submit their will queue? They can submit their will queue via the app. Like I said, they can submit it through our website. They can email it to us, fax it to us. They can even text it to us. Then we open up an intake and you'll get a confirmation email and a text message letting your members know that we've opened up the intake. It'll give them the intake number. Usually within 8 business hours, one of our paralegals will reach out to the member to review their questionnaire and to get any missing information. We'll also, if the member is not available, we can schedule a phone appointment with them and be available when they're available for the members. So that's what we do in the initial process of opening the will and getting the will prepared. Once the will is prepared, the paralegal will prepare the will and all the necessary documents. The attorney will review it and then subsequently reach out to the member again, and the member will connect with the attorney. They'll go over everything. And the reason why we do this 2-step process is because people may change their mind and the attorney will give them more information. And this is a big deal. You're leaving your assets, or you're going to have someone in charge of your estate. So they need some time to think about that and connect with the attorney. So once everything gets a stamp of approval from the member and the attorney, we will email it if the member would like us to email it to them. And then we also mail it out to them as well. Just to put this caveat out there, the US mail system is slow these days. And as of October 5th, they're even slower. So if a member says to you, hey, I've talked to the attorney, they said they were going to mail out my will, I have not received it yet, do not hesitate to reach out to us, and we'll check where it's at as far as make sure we did mail it. And if we need to remail it, we'll be more than happy to remail it. If we need to email it to someone so they can get it printed for the member, we will do that. But we've noticed that the mail is taking a lot longer than normal. So anything else you need me to say, Ed? I think I covered everything.
I'm sure I'll miss something else before we're done.
Just let me know.
Thank you. Okay, so we just went over that. Thanks again, Noemi. Any questions about this stuff, feel free to ask after the presentation's over. And finally, for 9 out of 10 clients, we do what's called the basic estate planning package. And that includes your will, your durable power of attorney, medical power of attorney, and living will. Those 3 documents get 9 out of 10 clients exactly where they need to be, regardless of what's going on. If they have children, if they have heirs with special needs, if there are beneficiaries that have trouble holding on to money or spending it wisely. And these documents they seem basic on their face, but they do a lot and they're quite effective.
Hey, Ed, if I can, one more little note. Another document that our firm provides to our members, I'm not sure if this is the same across the board for those folks that are logging in from other states, but if our member has minor children, if they would like, we can provide them with a medical power of attorney for their minor children. Say they spend a lot of time with grandma and grandpa, and something were to happen, we can prepare the medical power of attorney form and we will give it to them at no charge. Okay, go ahead, Ed. Sorry.
Thank you. Special situations, children with special needs. And this really comes into play if your child is receiving government benefits, or if you will be applying for government benefits on their behalf. If a member's beneficiary or child is receiving SSI benefits or is going to receive SSI benefits, a special needs trust is needed. Again, this goes back earlier when we discussed what happens if, for the single person without children, if they have a parent that is disabled or in nursing home receiving Medicaid. Similar situation here, where if you leave property to someone that's receiving government benefits, there's a good chance it's going to end up disqualifying them from receiving any more benefits, because you just gave them all that money that they otherwise wouldn't have had to spend on those benefits. Special needs trust has a bunch of different provisions in it that kind of get around or satisfy the requirements of the statutes that would not disqualify those beneficiaries from receiving an inheritance from you. Their discussion, these things are going to be more outside of the basic estate planning package. If we get into the more advanced trust planning. So first on the previous slide would have been special needs trust for your children. If you're someone with assets over the federal exemption amount, so if you're pushing $12 million in your estate or 24 in between you and your spouse, we're going to need to think about some more advanced estate planning to save income tax if possible, and to make sure we stay underneath that the federal state tax exemption, which is going to change here at the end of the year. Most recently, I've heard it's going to be $1 million. I don't know if that's changed. I can't tell you how recently that was. We won't know for a little bit longer, but if you're pushing these. Yep.
Sorry. If I may, just so you know, these special situations.
No. I'm not gonna eat it yet.
Hold on. Let me mute someone. Hold on. Okay. Sorry. These special situations will be a benefit 5. These do not fall under the benefit 1 of the member's plan. So this would be a B5, and typically Ed will, regardless of where your member lives in Pennsylvania, Ed can absolutely assist them, even though we're in Pittsburgh, your member may be in Lancaster. It's not a problem. Ed can assist them. So it's not uncommon for us to refer someone directly to Ed, because again, he's been doing this for a while and he would be the best person suited to assist your member. So anybody that falls into these special situations will be a B5.
Thank you for the kind words. Naomi. So like Naomi said, if you fall into one of these special situations, you'll be referred to me, special ed.
I like that. I'm gonna have to start calling you that.
Thanks. Members who have out-of-state property may wish to avoid multiple probate proceedings by establishing a trust for that property. This goes back again to earlier when we were talking about having a trust in transferring property at least 1 year before your passing. Those transfers to your trust will get it outside of your estate, and then it's going to depend on what our goals are. If we're trying to avoid probate, or if we're trying to avoid inheritance tax, a portion of inheritance tax, or inheritance tax entirely altogether. Same for the federal estate tax exemption. All these things, they need to be addressed and thought about, planned for, before we get to, the impending event, whether that's a gift that's going to go over your federal gift tax exemption, or if it's going to be something subject to inheritance tax or federal estate tax. It's better to think about these things sooner than later and not put them off, because if you think about it, when whatever's going to happen is coming up, the impending event is getting closer, usually it's a little bit too late. So if you fall within any of these special situations or circumstances, we recommend you contact Legal Shield sooner than later, and they'll get you in touch with me. We can talk about what's going on in your life and what your goals are. And I'll get you where you need to be. That is the end of the presentation. Thank you, everyone, for listening. Thank you, Noemi, for filling in when you needed you.
You're welcome. We'll go ahead and let's see what questions we have here in the chat. And I see we have someone from Texas here. Thank you so much for joining us. Again, some of these laws are just applicable to Pennsylvania. You'd have to check with your provider firm to see what laws apply in the state for yourself and your members. Just wanted to throw that out there. Ed, we have a question. What's the range of costs we're looking at for a typical probate up there in Pittsburgh, or perhaps the overall costs associated with a typical estate?
State administration, it really depends on the nature of the assets, whether or not there was a will, if there's a trust, how many assets, if there's complex situation, if it's complex distribution scheme, whether it's your will or your trust, things like that. But in general, our firm charges, well, the estate administration is not included in the Legal Shield. It would be a B5 to me. We typically charge.
But you would still get the discount. It's a
Right.
B5 with your referral discount. So you'll still get a Legal Shield discount. It wouldn't be free.
Correct. It's usually about a minimum of $2,000 legal fee, and then anywhere from $500 to $700 of out-of-pocket costs, which would be things like those probate fees, the legal advertisements for the estate in the newspapers, or there's additional inventory filing fee, things like that. That would not include the inheritance tax, which is 4.5% for many old descendants. So grandma to mom to me. It is 12% for siblings and 15% for everyone else.
Thank you, Ed. Let's see here. So Harvey had a question. He's had this question come up several times. If my spouse is no longer living and the estate is to be divided up equally to the children, do the shares of adults decrease? Does the share of an adult deceased child go to their spouse or their children? If it doesn't go to the spouse or the deceased children, how can I make it to do that when I'm using the questionnaire with the members?
I missed a few things, I think. What was there a will involved?
Harvey, go ahead and unmute yourself and ask the question.
All right, thank you.
You're welcome.
So I guess there was kind of two parts to that question. One is, if my spouse passes and now I pass and have a will, and my will states that it all goes to my spouse. If she's not alive, it gets equally divided up to my children. What happens if my oldest son, who is married, is passed? Does his share go to his wife, or does it bypass her and go to his children?
It's going to depend on what the will say, the parents' will. I forget, which one did you say was the second to pass, the mom or the dad?
The dad.
So,
So I have my will in front of me now, and it states that it goes to my wife. If she's no longer living, it gets divided equally to my children.
yeah, so
And
it'll
the-
depend on those parents' wills if they want their property to go. Or at least the wills we prepare would state whether or not a predeceased child's share would go to their descendants, or if it would go to the remaining children.
So what about, because I've had this come up where none of your wills that you've done for me, where a child passed and then this child's parents passed, and the share that this child would have received got passed on to their children and not to their spouse, who could have used it to help raise the children, because it wasn't, the spouse of the child was not named in the will.
That's common for that to happen. So if you are running into people that want to have the spouse name, then that's something we could think about having to adding to the will questionnaire.
So that was going to be, that was the second part, the second question then. If I want that to happen, how can I word that in the will questionnaire? Because I sit, as Noemi knows, I sit with a lot of my clients to fill out the will questionnaire. So what language, or where should I word that it goes to a child and or spouse?
Harvey, you could always add a second, like just a Word document, or something written on a notebook paper, when because you always send us your will cues, with that added on in the back, that special provision and just an explanation of what they want, because I know
Sure.
that there's not a lot of room on those will questionnaires to put that information in, so you could do it that way.
Okay.
Yeah, and then
Perfect.
I forget which page it is, but there's 3 ABC options towards the back or middle, maybe. I'll put that, just make sure it's highlighted or underlined a few times.
Okay.
That you want to leave that to the surviving spouse of the child.
Perfect. Thank you.
Because it's kind of hard to go through all the contingent circumstances on that one piece of paper, unless you wanted to type it out on an attached page. But just so the attorney knows to look for it, or recognize it when they see it, and they can discuss it during that consultation.
You guys are the best as always.
Thanks, Harvey.
Other questions?
Sorry, I muted myself by accident. Let me see. We do have, what is the usual turnaround time for wills, living wills, power of attorneys to be completed and sent back to the member? Good question, Jimmy. It depends. And what I mean by it depends is if all the information is provided to us up front, it should typically take about 5 days, 5 business days turnaround time. I would say probably about 90% of the time, we don't have all the information from the member, and we do play phone tag going back and forth with them. Sometimes the members will even tell us, hey, I need to think about this. This is a lot. Didn't realize what this entailed. And, can I give you a couple of days and get back to you? So, but typically it's within 5 days, as long as we have all the information. If not, it's at the member's request, or, at the member's time frame. Okay. Any other questions? That's all that we had in the chat. Does anybody want to unmute themselves and ask a question before we give you your night back a little early? All right. As always, you will find all of our webinars posted on our YouTube channel. There are other webinars that we have done out there. Ed, do you want to talk about these 2 websites that are listed here? Do you know the intestate calculation looks like?
Oh, I'm not 100% familiar with that, but
Okay.
I believe it gives you a picture, paints a picture of what happened. You put in your asset values. It doesn't need to be approximate; it's just an approximation. of what they look like today. And then I believe it gives you the option of saying how you want your property to go. And then it just gives you a snapshot of what it would be look like, how much more it would cost to have your estate, the administration of your estate, if you didn't have a will compared to having a will.
Okay,
And
thank
so
you.
you see that, and then kind of, paints you that picture so you see something instead of just hearing it.
Okay. And if you visit our website under trust and estate, there's some information on there as well. And then as always, if you have any questions, please feel free to reach out to us. We'll be more than happy to try to assist you where we can.
Thanks, Naomi. Thanks, everyone. Great speaking with everyone today.
Oh, hold on one second, Ed. Go ahead. Do you have a
Hey.
question, Jimmy?
Not me, but I see that Randall Cutler has a question in the chat.
Oh, right. I'm sorry. Did I miss him? I thought we talked. Okay. Ed, how about the cost of trust and the associated documents? Are they with a discount or without a discount?
Everything if you're a Legal Shield member, everything will be discounted, if not free. So you won't be paying full freight for anything. For revocable trusts, it's typically starting at $1,500, and that would at least get you your, if you're a Legal Shield member, you would have your powers of attorney included, complimentary, and depending on how crazy and nutty you wanted to get with your will and trust, those will also be included in that starting $1,500. But on average, I'd say $1,500 to $2,500 for the revocable trust.
Okay. Any other questions? Okay, if we have no other questions, we'll go ahead and give your night back to you a little early. Again, thank you so much for logging on. We appreciate it. I believe we will be having another will webinar, no, excuse me, not will webinar. I'm sorry. We'll be having another webinar next week sometime, and that will be hosted by Deshawn Furness, and she will be providing a guide to how to navigate through family court and custody court. So that's going to be another good one. As always, you can go to our Eventbrite page and see what other upcoming events that we also have. All right, everybody, have a good evening and thanks again.
Thanks, everyone. Good night.
Bye-bye.